I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are venturing into number 77 on our compilation list. We will be in 3 different judges' courtrooms dealing with 3 different sovereign citizens. But before I give you the rundown on those judges, just know that there will be no commentary at the end of this compilation. Chapters will be added for your convenience. And also, don't forget to continue your participation by liking, sharing, subscribing, commenting, all of those great things. Now, the judges' courtrooms that we will be in today. First, we will be in the courtroom of Judge Jeffrey Middleton out of the state of Michigan. Second, we will be in the courtroom of Judge Guerrant out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Joseph Slavven, also out of the state of Michigan. Listen, it's about that time, guys, to jump into number 77. So without further ado, guys, let's go.
Is he in custody? He was here. David Zambrano.
I think he's outside the door, sir.
All right. David Zambrano. He's busy.
How you doing today?
Doing all right. It's a Tuesday. We got lots to do and we're making progress. Mr. Zambrano, we've had a hard time getting you in here. We got a lot going on here. In file 251521, you got a ticket on July 29th for driving without insurance and no valid license in possession. Those are both written under state statute. On July 25th, you got charged with driving with an unregistered vehicle in file 1523. On July 14th, you got charged with driving suspended and unregistered vehicle. That one's under White Pigeon ordinance. So July was a bad month for you. Then we set this a couple times. The city or the village of White Pigeon in the July 14th case has agreed to dismiss the charges if you plead to allowing another to violate the motor vehicle code. I'm not sure what the county's position would be on the other charges. And frankly, I don't know why they didn't charge him with driving suspended on all 3 days. Let's take a look. And then you'd missed a date and then they reset it and I don't know what happened, but oops. It's the last guy.
Your Honor.
Yes.
I'm appearing here today pro se in the special appearance sui juris and in propria persona. I respectfully assert my rights to represent myself and have my constitutional rights recognized and upheld throughout these proceedings.
All right. Well, that's certainly your right.
Thank you, sir.
You live in South Haven?
Actually, I'm the sojourner of the land. I don't have a residency at the
Well, the reason I ask,
I once did,
if
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these? Some are under White Pigeon ordinance, some are under state statute. You can help alleviate this by getting insurance, getting a license. It looks like you have some out-of-state problems. And you haven't had anything on your Michigan record in a long time. 12 years or more. So how would you like me to proceed here?
What are the charges? Again, all the ones that.
Well, right now, you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again. You're charged with no insurance. That's a misdemeanor, punishable by up to a year in jail, a fine of not less than $200 and not more than $500. That was on July 29th. On that same day, they charge you with no valid license in possession, even though your license is suspended. They didn't charge that. No operator's license in possession is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. On July 25th, take a look at that one. One, 5, 2, 3. No, that's the 29th. It's the same as the others. You got no insurance, no ops on person, unregistered vehicle. That was on July 29th. And those are all under state statute. On July 14th, you got another ticket. Take a look at that one. 1560. And that one, they filed a formal complaint that alleges that you were driving suspended and you had an unregistered vehicle. And that is under White Pigeon ordinance. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. And then they charge it, you have an unregistered vehicle. You could help all of these if you got insurance, a registered vehicle, and worked on getting your license back. So one thing I could do is set all these cases for a pretrial on the same day with the White Pigeon Village attorney and the county attorney and see if they can come to some resolution of all the charges. Is that acceptable to you?
Actually, no, I have a few questions I need answered before we proceed. I don't understand the nature and the cause of this action against me. And I'm is this a civil or criminal? It's criminal.
All right, you were here with your mom and she's here with you. So it's good that you support each other. She asked me the same question, which points out to me that you're not qualified to represent yourself if you don't know the difference between a criminal matter and a civil matter. These are criminal matters. They could result in a jail sentence and a sanction on your driver's license.
Thank you, Your Honor. The record reflect this is a criminal action then?
Yes, it is.
Okay. I just got to look at my papers and stuff.
All right.
So So my next question about it is, Constitution grants this court two types of jurisdictions.
Yes. All right, we're not gonna get into this, what I call Jabberwocky. It has no legal effect. I don't know where you get it or where your mother got it, from a online source or somebody that told you this, or they're giving you bad information. These are criminal matters. They're not terribly consequential. Normally, you wouldn't go to jail for these, although they do carry a potential jail sentence. You don't necessarily subscribe to our system, but I certainly don't subscribe to whatever you got written on the paper there. I propose we set this for a pretrial, and you try to get a registration and insurance, and then come in and share it with the prosecutor and the city attorney, and see if we can resolve everything. If we can't, we can set it for a trial, including a jury trial, I suppose. It's two different incidents. So it would have to potentially be two different cases. What I propose is you trying to do some things to get situated and have a pretrial with the city attorney and the county prosecutor.
Your Honor, I'm gonna have to object to that. Before we can proceed, I need to know, it's upon the authority of the Sixth Amendment, I need to know the nature and the cause of these charges. Could you tell me if it is a common law?
No, these are statutory offenses written under the authority of the people of the state of Michigan. One of these is under the insurance code, and one is under the motor vehicle code. The others are. And I don't really wish to engage in this discussion. We've got about 40 other people waiting for their case. And you want to talk to me about how many angels can fit on the head of a pin. You're charged with two separate traffic offenses on two separate occasions. You have a right to have an attorney. I'd be happy to appoint one for you, but you don't want one. You want to represent yourself, which is your right, but you don't have a right to waste my time. So if you either want me to set it for a pretrial, I can do that. That would be my preference. Then you can sit down with both prosecutors, ask these questions, and see if it can be resolved. If it can't, we can set it for a trial, either in front of a judge or a jury. So what would you rather do here today?
Well, on the authority of the Sixth Amendment, I'm asking that the court discloses the jurisdiction that I ask.
I just did.
You said it's a statutory jurisdiction?
Yes, you're supremely unqualified to represent yourself in this matter because someone sold you a packet of information that has no relevance in the modern universe that we live in. So I'm gonna set this for a pretrial.
Your Honor, that would be practicing law from the bench if you proceed without me.
I'm a lawyer, I'm a judge, I practice law from the bench. I do it every day, all day. And
I'd like to, I do have a few more questions about this.
I don't have any more time to answer your questions. I have a question for you. What do you want me to do with it? Set it for a pretrial or set it for a trial?
Under a statutory jurisdiction, I've never heard of, I need to know where I can find the published rules of the criminal procedure under that.
Well, you can certainly find them on the internet. They're in the public library. You just put the number of the citation, 257904 under the Michigan compiled laws. All right.
Was that
Mr.
2-5?
Stickley is the chief public defender. He's had an opportunity to talk with you. Mr. Stickley, what's your recommendation here?
My recommendation would be to set it for a pretrial. I'm happy to spend a few moments with this gentleman and show him where the statute is
All
and maybe
right.
where he can Google or library.
And he's entitled to have copies of each of the tickets and the complaints, and
Yeah.
so he can see it. So if you'd like, we'll get copies of their tickets for you. You got the ticket, but there's a formal complaint. I'm gonna set it joint with the city and county for 2 weeks. October 7. Mr. Stickley is the chief public defender, and he's not exactly representing you. He's here to make sure that your rights are protected. And he also can give you some advice and maybe point in the direction of what you want to do. Again, it would be helpful if you would come in with insurance and a proper plate and perhaps an effort to get your license back. You don't want to stay on the driving suspended merry-go-round because it's very hard to get off of it. Once you get suspended, you live near White Pigeon. The other problem is I don't have an address for you. So I need a mailing address. When you go out to we can use your mom's address but I'm gonna need you to give the clerks some sort of address where we can send things to you.
Could you deliver it general delivery to the post office?
Well, you can give them that.
Okay.
All right, I'm gonna want you to take him out, get him a proper notice for that pretrial on the 7th. Mr. Stickley will meet with you and get some of that information that you're looking for. All right, sir, I'll see you on the 7th.
Finally, I have the Heights at Dunwoody versus Brittany Berry.
She's here.
Well, she's refusing to identify herself, so unless she does that, yeah.
I haven't refused to identify myself. As I previously stated, I'm the authorized representative for that
Okay,
state.
is your name Brittany Berry?
I'm the authorized representative for that
Okay.
state.
All right, Ms.
family.
Berry, we're going to be going forward on a judgment on the pleadings in your case. Mr. Williams, if you'd like to go forward on that now, we can do that.
Oh, sure, Judge. I'd be happy to. I'll just move for judgment on the pleadings, ask for a written 7 days,
Okay,
which would be, was that 22nd?
that is going to be March 22nd.
I have an objection. A writ of discovery was to file.
I understood. I saw that your motion, you're essentially stating that the laws of this state and the country do not apply to you. That is not, that motion has no merit and it is denied.
It
Total
did not
judgment.
state that it does not apply to me.
Yep, that's fine. All right, Ms.
I have all
Whoever this
my rights
is.
are reserved in reference to the 4th Amendment and 14th Amendment.
All right, go ahead, Mr. Williams.
Yes,
my-
Judge. The total amount due to the 22nd is $2,998.28 plus costs.
Okay, and that's due from when? When was the last payment made?
Last payment was in January.
I object for the record.
Overruled. So January, what is the monthly payment?
The monthly rent in this case,
Objection for the record.
Okay, you're overruled.
is $22.40 per month. There's a portion due from February.
Ms. Rodriguez, if you could please keep whoever this is muted.
There's a portion that was paid in February and then March rent's due. That's why there's only 12/31/12 due.
Okay, so there was a partial payment,
Correct.
and this is just includes
For the
rent.
record, this is a denial of.
All right.
This just includes rent and one late fee of 10%.
Okay. All right. All right. So that was what the order will look like. Ms. Bear, or whoever you are, I am going to remove you from the proceedings now.
Mr. Martin was here and now he's gone, so.
Mr. Martin was here. And now he is not here. What time was that one set? That was set for 8:30. People versus Eric Martin.
Good morning, Your Honor. MIDC counsel on behalf of Eric Martin, Josh Hadley, P number 80080.
All righty. Today was the date and time set for a settlement conference. Mr. Martin had appeared and he signed out and is no longer here. He left the court, the Zoom court. There was also a motion and demand to replace his current attorney, Joshua Hadley. You would be the second or third attorney, I think, I've appointed to Mr. Martin.
I can't speak to it, Your Honor, but I do believe that that's correct. I know I'm not normally one of your house counsel attorneys. I was reached out and spot appointed on this. I believe I'm successor, maybe third attorney on the case.
Right.
Judge, he is back in the waiting room now.
Oh, wait, he's back in the waiting room now. Here he is.
And Your Honor, I was not served a copy of the motion to replace me, so I will not stand obviously in opposition if that's been filed with the court.
Well, it's been filed by Mr. Martin, so it was handwritten. Mr. Martin, turn your video on, please.
I'm doing that. All right.
Yeah, this is People of City of Taylor versus Eric Martin. Today's the date and time set for a settlement conference in this matter. Mr. Martin, you had filed a handwritten motion to replace your attorney, Mr. Hadley. Mr. Hadley is like the second or third attorney that I appointed to you on this driving on a restricted license. And replace him, which will require another. It says that your attached motion, you'd like to fire the attorney and replace him, which will require another appointed attorney, time to get familiar with this case and your defenses. So there's nothing wrong with this attorney. What's the problem with this attorney? He's a very highly qualified attorney who I appointed to you. This is a driving on a revoked license. I'm not sure what the issue is here with this attorney.
Pointed out in the motion and demand to get rid of him was replace him was because
Hey, Mr. Martin, hang on. I can't hear anything you're saying because the tubes behind here. All right, go ahead.
Yeah, just as I pointed out in the motion was because he told me that I can't say nothing during a trial. If he talks, I can't talk. Basically, I have to violate my own right to freedom of speech. Yeah. And what was the other reason? Let me refresh over it again.
Okay.
And there's other reasons. And plus, he kept cutting me off several times as we was talking. Not like it was a one-time thing, like normally happen. People don't intentionally, might cut off. So it happened several times ago to show he was doing it intentionally.
So you say you want to talk at trial. You have two different options as far as talking at trial. One is you have the right to testify on your own behalf if you want to. And no one's going to stop you from testifying on your own behalf. Now, if you're planning on doing that, your attorney can ask you questions, and you can also be subject to cross-examination, just letting you know. And you'll be under oath. So any sort of perjury or anything like that, you could be subject to obviously the penalties of perjury if there was any sort of untruths that were stated by you on the record, on the witness stand. Now, the other way you would be able to speak on your own behalf is if you're representing yourself. So I think what Mr. Hadley is talking about is like if someone's asked a question and he wants to say objection because there's a legal reason to say objection. I don't need both of you to say objection. Just one person can say objection. I think that's what it's going to be confusing if you're going to try to talk over top of your own attorney when it comes to that sort of stuff. If you want to represent yourself, you're more than welcome to represent yourself, and you can talk. You can be the attorney. You can say objection and that kind of stuff. But in that situation, I would still have Mr. Hadley there as a standby so that you can ask legal questions. But there's no reason to fire Mr. Hadley. He's a very competent attorney, and this is a very straightforward case. You either had a license at the time you were driving, or you did not have a license at the time that you were driving. And all we have to have is, as far as the elements go, we have to have a witness that shows that you were operating a motor vehicle on a public street and you didn't have a license. Those are the elements of the case. So I don't know who the witnesses are. We haven't heard any testimony, so I'm not going to get into any of that stuff. But I'm pretty sure that Mr. Hadley can handle a case like this, or be the standby there sitting with you in case you have a legal question when it arises. So that's for that reason, I'm going to deny your motion because you have very competent counsel. You requested counsel, and I don't see any legitimate reason to fire this attorney and hire a new one, especially when you stated right in your motion that our attached motion and demand to fire the attorney and replace him, which will require another appointed attorney time to get familiar. I'm not kicking this case down the road again and adjourning it out again, just so that we can stall for more time. So there's literally nothing in the elements that Mr. Hadley isn't aware of. So I'm going to deny your motion. Now, if you want to represent yourself, I'll have Mr. Hadley be there as your standby attorney so that you have an attorney that you can ask questions to right in the courtroom. Or Mr. Hadley will be the one who's going to represent you. And if you want to testify, that's entirely up to you.
Your Honor, if I may briefly, as Mr. Martin's waived attorney-client as to the contents of our communication, I've never told Mr. Martin that he was not allowed to testify on his own behalf. For the record's sake, Mr. Martin has proposed that we would have dual opening arguments and dual closing arguments if there was a difference in trial strategy. I've explained to him that the court's not going to entertain tag teaming this proceeding.
You know what? Listen. If you want to say a closing and he wants to say a closing, sure, go ahead. I got no problem. The court is not, the court is very, 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 very astute in the law. And you know what? If you want to talk, you want to do an opening argument, you want to do a closing argument for yourself as well. Listen, I'm just going to remind Mr. Martin that you have a right to remain silent and not have any of that silence used against you. But if you want to get up and speak, I'm going to caution you right now of what you're not going to do. One, you're not going to testify until you've actually testified. You're not going to talk about things that are not in evidence. So if you're going to be like, hey, I did this or they did this in the opening statement. Now, if you're going to want to say that it's going to, like everybody else does in their opening statements, here in this trial, the evidence will reflect, or the evidence will prove X, Y, and Z, talking hypothetically. Sure, but if you plan on not testifying, then you better not testify during your opening or closing statements, because you're not subject to cross-examination at that point, and that would be unfair for the other side. If you are going to testify about your own opinions, about your own statements of fact that you think happened, you're going to do that on the stand if you want to do that, or you're not going to say it at all. You understand, Mr. Martin? Because that's not fair to the other side. That's like letting you move chess pieces and the other side doesn't get to move any chess pieces. Because there's a whole rhythm, there's a whole flow to it, there's a whole fairness to the whole process. So if you're going to testify during your opening or during your closing statements, then you're going to testify on the stand. But if you're not going to testify on the stand, which is your choice, you have the right to remain silent on that, then you're not going to bring up things that aren't in evidence, because your testimony isn't in evidence. So you're not going to sneak it in or slide it in during your opening or closing statements. Do you understand that?
Before I answer that question,
Mr. Martin, the answer is yes or no.
respond.
Do you understand the statement that I just stated?
I comprehend it.
Okay, you
but now let me
comprehend it.
say
Very
something
good.
else.
So next topic is, everybody's ready to go. That is, set for the trial. And, we'll see everybody here for trial.
I have some objections and I have something else to say. Now, I never said that
Today was-
Joshua never said he couldn't testify. He wasn't talking in that because I couldn't speak. He was
It's already been resolved. It's already been resolved. If you want to make an opening statement, you can make an opening statement. If you want to make a closing statement, you can make a closing statement. So yeah, I got no problem with both of you making the opening and closing statements. And with regard to testimony, if you want to testify, you can testify. If you want to remain silent, you have that constitutional right to do that too. So court's not stopping you from doing any of that. Okay, so the motion to remove Mr. Hadley has been decided. So there's no more need nor discussion for that. I've already made my ruling on that. So that was the point of today. Was the your motion was up for today. We've made a ruling on that motion, and we'll see everybody at trial. Have a good rest of your day, sir.
I have a motion to make.
Briefly,
I have a motion to trial based on other motions that I filed to dismiss the case, and they have not been ruled on yet.
So you say your motion to dismiss?
I have several motions to dismiss already filed in this case that are
Right, and I already ruled on your motion. I already ruled on your motion to dismiss. And if you're just going to refile the same thing, then it's still dismissed. You can't just keep filing the same motion to dismiss.
One of those same motions. Now I'll go over the motions I'm talking about specifically here. One based on the 11th that I. August
So
19th.
we'll hear any other motions on the day of trial, sir. So be prepared because we'll hear those in person here and before the trial starts, if the trial starts. Because if your motion is successful, then we obviously won't start it. But we're not hearing those today. Those weren't scheduled up or noticed up to be heard today. Those are going to be heard on the day of trial, so we can do them here in person. And then if your motion is successful, then we won't have trial. If it is not successful, then we will. But that way everybody will be ready to go on that same day. So we're going to see everybody on the day of trial, and any other motions that you have, we will take care of at that time. Mr. Hadley.
Your Honor, one, I would like to get a working phone number for Mr. Martin. I've been unable to reach him for several weeks.
Mr. Martin, do you have, I'm going to put you into a breakout room, because I don't want to broadcast your information online.
And then second, Your Honor, I've been
Mr. Martin, hang on. Mr. Martin, hang on. Mr. Martin, hang on. Mr. Hadley, what was the second part of your?
Thank you, Your Honor. I have not received or been able to get copies of any of the pro se motions that have been filed other than the motion for a hearing to determine nature, cause of case. Would it be acceptable to reach out to your staff to get copies of these pro se motions in advance of the trial next week?
Yes.
Thank you. That's all I have, Your Honor.
All right. So Mr. Martin and Mr. Hadley, I'm going to put the two of you into a breakout room so that you can swap information as far as phone number and things like that. So there you go.
Thank you, Your Honor.
Here.
Yep. I still have a verbal motion to make, Joseph.
All right, so go ahead and talk with Mr. Hadley in the breakout room. You can sign out from there.
I'm not threatening you. Say one more word and that's 30 days. 30 days.